So, you're craving a McFlurry. You've made the pilgrimage to your local McDonald's and, surprise, the ice cream machine is down once again. The little mystery of the broken McFlurry machine has been such a running joke that there's an entire website tracking the status of McDonald's ice cream machines nationwide. But it's much more than a joke. These machine failures cost McDonald's franchisees real money in lost sales and customer frustration, a frustration that only seems to multiply every time a machine is broken down. But for years, the McDonald's franchise owners have been forbidden to fix these machines independently, all thanks to copyright. Yes, frosty goodness is being denied over copyright on an ice cream machine. And Taylor, the machine's manufacturer, holds the exclusive rights to service and repair, controlling both the tools and knowledge required to fix them. However, glory be, as just this week, the US Copyright Office handed down a game-changing decision, granting a much-needed right to repair exemption. So what does this mean for franchise owners? And more importantly, does it mean there could finally be a more reliable McFlurry and glorious McDonald's Sunday in our futures? Let's dig in. If you've ever fixed your own car, swapped out a phone battery, or even tried a hand at some home repair, you've dabbled in the world of RighttoRepair. And the stakes are even higher for business owners. Imagine being legally barred from fixing your own equipment. Customer after frustrated customer walking out that door and taking with them thousands in lost sales. The RighttoRepair movement fights for the rights for owners to fix their own property without interference. Now, this sounds pretty straightforward, but companies like Taylor, who in this case is the McFlurry machine manufacturer, have argued that allowing third-party repairs would violate their copyrights. Under the Digital Millennium Copyright Act, Section 1201, the act of bypassing a digital lock on equipment, even for maintenance or repair, was off-limit to anyone but authorized Taylor technicians. You might own the machine, but if it breaks, only Taylor could fix it. Imagine the pure frustration of franchise owners losing around $625 per day on a broken McFlurry machine and having to wait up to 90 days for Taylor's techs to fix it. You can do the math. And of course, it's not just the money. It's frustrated customers who might now patronize your competition. Franchisees began pushing back, and they weren't alone. Consumer advocacy groups like Public Knowledge and the repair site iFixit stepped in, advocating for a DMCA exemption to repair these retail-level food machines. So, what finally tipped the scales in favor of the franchisees' owners? Well, we're talking about big players here. The Department of Justice, the FTC, and the National Telecommunications and Information Administration, among others, all backed the franchisees in this RighttoRepair battle. Taylor, the machine manufacturer, on the other hand, insisted that allowing anyone else to repair their machines would undermine their intellectual property and expose trade secrets. Does that sound a bit dramatic to you? Because it certainly does seem so to me. Taylor argued that their machine software, which requires a unique diagnostic tool and undocumented key press sequences to access, couldn't simply be handed over to anyone. But franchise owners countered with data showing the financial toll and delays caused by these restrictions. The Copyright Office finally acknowledged the inability to repair these machines caused significant adverse effects on non-infringing repair uses, allowing franchisees a narrow exemption for diagnosis, maintenance, and repair on machines like Taylor's ice cream behemoth. But here's where things get a bit more interesting. The exemption, at least for the moment, only applies to retail-level commercial food preparation equipment. Industrial-level machinery, for the moment, they're still off limits for third-party repairs. So while the ruling is a win, it's hardly the blanket approval that some hope for. So how exactly does this exemption make it through the Copyright Office? Let's dive into the behind the scenes, push and pull. A public interest group called Public Knowledge and the repair site iFixit might sound like unlikely heroes, but these two groups played a huge role. After finding that Taylor's machines had lots of easily replaceable parts, iFixit and Public Knowledge petitioned for the RighttoRepair exemption, arguing that copyright law was being twisted to restrict basic fixes. In a clever move, they presented evidence from franchise owners who faced constant hurdles with Taylor's cryptic error codes, non-transparent manuals, and software locks. The Federal Trade Commission added weight to the argument, emphasizing how these repair restrictions limited competition and jacked up repair costs. The Copyright Office, for its part, listened, acknowledging that the current prohibition on circumvention directly affected the ability of franchise owners to make non-infringing repairs. Meredith Rose, a senior policy counsel at the group Public Knowledge, summarized the win this way. There's nothing vanilla about this victory. An exemption for retail-level food preparation equipment will spark a flurry of third-party repair activity. Her team's relentless advocacy made this win possible, showing that sometimes copyright law and common sense can actually align. But with this exemption in place, what does it really mean for the day-to-day McFlurry craving customer? For franchise owners, this ruling is huge. Before the exemption, owners couldn't even perform routine diagnostic checks without fear of a copyright infringement lawsuit. Now they can sidestep those notorious digital locks that were keeping their machines down and profits lower. The decision marks a big shift for food industry overall, signaling that companies can't indefinitely lock their equipment from those who buy it. For customers, the more proactive franchisees are with repairs, the fewer out-of-service signs you'll see at your local McDonald's. According to the tracking site McBroken.com, nearly 15% of McDonald's ice cream machines are typically offline on any given day. So while we might not see instant results, this ruling promises a lot more McFlurries a lot more often. The big question now is, what's next for the right to repair movement, and will this narrow exemption grow? The McFlurry exemption has opened the door, but will this be a new turning point for right to repair laws more broadly? Many believe it could be. By showing the power of organized legal and consumer advocacy, groups like iFixit and Public Knowledge hope to expand the right to repair to more types of equipment, including industrial machines, automobiles, and even consumer electronics. These groups argue that when consumers and business owners are left helpless by tech locks, it stifles competition and drives up cost. On the other hand, companies of a similar mindset to those of Taylor might argue against these changes, arguing that tech security and IP rights are needed for safeguarding. But as the White House's previous executive order supporting right to repair shows, the tide could be turning. The McFlurry ruling might be just the crack that widens the door, potentially changing the landscape of repairs for countless devices and machines. And while it's a win for the lovers of McFlurry today, the long-term impact on the right to repair movement could be huge. With this victory in the books, the path is paved for more right to repair wins in the future. But in the meantime, this decision alone might mean a whole lot fewer broken McFlurry machines and a whole lot more satisfied customers. But now, my friends, I'd like to turn things over to you. I have a few questions for you to consider in the comment section. 1, do you think companies like Taylor should be allowed to keep the repair tech a secret, or do franchise owners have a right to open access? 2, do you think that this ruling will actually improve the availability of McFlurries, or is it too little too late? And finally, are these copyright restrictions protecting innovation, or are they just keeping everyone locked out of their own machines? Drop your thoughts in the comment section below. I can't wait to see what you have to say. And also let me know what your favorite kind of McFlurry is. Until next time, I've been Uncivil Law. And remember to keep it uncivil out there.